welcome back to Facebook Live with Connaughts. My name is Anna Rana. I'm a solicitor advocate at Connaughts. To my left here, I have Awais Javed, solicitor who qualifies in immigration and family matters, and to his left is Sharia Khan, head of immigration. Now, we've received a lot of inquiries over Facebook. We will deal with them one by one. We've only selected a few of the inquiries, but before I go on to these inquiries, I'm going to ask Mr. Sharia Khan a question about his recent matter. Now, you've been granted permission on a human rights claim. Can you please tell us about that?
Yes, that's correct. It's quite an exciting case, and I think possibly could have the potential to be one of the biggest cases of this year in immigration. So the argument that the upper tribunal is going to be dealing with next month is that whether a human rights application and a human rights claim necessarily needs to have a paid application form, or the general process is if you make a human rights claim, the Secretary of State would reject that application as invalid and would say you need to accompany this with a paid application form, which basically means you need to fill out an application form, which isn't a hassle, but also pay the fee for that application. And these days, as most practitioners would know, we're looking at a fee of approximately £1,000 per application. So if it's a family of 5, we're looking at £5,000 just to have a human rights claim or a human rights application submitted. And of course, most families face huge difficulties with this fee, which is in addition to the immigration health surcharge, which is also close to about £500 per head. So the challenge that we mounted is that these applications, in cases such as these where the applicants cannot afford it, should not have a fee. And that's something that the upper tribunal should now consider next month. Did you want to add something?
Yes, it does include cases where, for example, Home Office, a lot of times when we used to write to them, they would send a red notice for a client and ask them if there are any further reasons you want to tell us about why you want to stay in the UK, and we would get the documents together, make representations, send it to them without an application form. All they would do is just write us a letter saying that because this is new evidence or fresh evidence, you have to use an appropriate application form, and we won't consider these representations at all.
That's correct. That's precisely what's happened in this case as well. So it's not a case that the applicant does not want to pay the fee at all. The applicants actually paid the fee once a year or 2 years back, and now there's been change in their circumstances, and that's why they want the Home Office to consider these fresh matters again, but they refuse to do so, and they say you have to make a paid application again. So it's quite in contradiction to the rules, as you said, because the refusals themselves say that under Section 120, if there are further grounds that you want us to consider, make representations. But when applicants do so, they say no, pay the fee again. So we've encountered more of that in the last 2 years. I'm sure you have noted as well. So that's what's the upper tribunal going to be dealing with, and we're quite excited about this case. So any applicants who are getting affected by such cases where they don't want to be encumbered by such a huge fee should follow our thread and see how this goes.
Excellent. A lot of times clients would ask us whether they can make a fee exemption application, for example, and I always tell them the threshold is very high. We need to show either they have very exceptional circumstances, or we need to show that they're basically destitute. And if they are meeting their expenses, for example, they have a roof over their head and they can meet their everyday expenses in terms of food, shelter, etc., then they cannot be considered destitute. Doesn't matter whether they have money to pay the application fee or not. So it's a very difficult test for any applicant who doesn't have money to pay the fee but has enough money to basically run their day-to-day expenses. Home Office still wants them to make a paid application with a paid fee without having any access to fee exemption. So from that perspective, I think it's a very interesting case, and I would request all our audience to make sure that they follow this lead case of Sharia's, because it can help a lot of people in the long run.
Absolutely.
Excellent.
Okay, moving on to the inquiries that we've selected. This inquiry is in relation to application on access to child category. Now, we've received 2 types of inquiries on this. One is that what if you have a child in the country, United Kingdom, who's British, and is there a route for you to make an application on that basis? And second question, similar to this, what if that child is not British? Can you?
Okay. I'm assuming that this is under the circumstances where child lives with one parent who probably has leave to remain in the UK and the other parent doesn't, and we want to know whether other parent can make an application to continue staying in the UK. Well, in that case, if child is British, then it's pretty straightforward. We need evidence that that a particular parent who's making an application has access to the child, so has contact rights either via court or via an agreement made with the other parent. So that parent can see the child regularly. If they're paying any maintenance amount, for example, we need evidence for that. And there are further two subcategories. They can make application under a 10 years route, or they can also make an application under a 5 years route, 5 years child route. For 5 years route, additional documents required as compared to 10 years route is that they need to show that they are able to maintain and accommodate themselves without recourse to public funds. This is generally applicable to those who already have leave to remain in the UK or have some sort of savings or income from which they can obviously maintain and accommodate themselves. In addition, they also need to show that they have fulfilled valid English language requirement, which is equivalent to A1, which is a very, very basic requirement. Either they can do IELTS, IELTS or Trinity basic A1 requirements. If they fulfill those requirements, they can actually make an application under 5 years child route rather than making it a 10 years route. So these are the basic requirements for this type of category. A lot of times we get clients where other parent is not willing to give access to this particular parent to see the child. In that case, we're not left with any option but to make an application to family court to get an order from the court, just to show that father can continue or mother can continue to see the child. If that is the case, unfortunately, we will have to take that longer route, which is generally very expensive as well. But as long as we have evidence that that particular parent has access to the child, can see the child, has contact rights, then that person can make this application. Coming to the other case where child is not a British citizen, then it can be further divided whether child itself has leave to remain in the UK or not. If child has leave to remain in the UK, we can still make application on the basis of the evidence we've just mentioned. But in addition, we will have to obviously make an additional human rights claim that if child is staying in the UK and this particular parent has to leave the country, obviously they will lose touch with the child. And then there is no particular category within the immigration rules where this application can be made, but application definitely can be made outside of the immigration rules in this particular scenario. And we've had cases where leave is granted to this parent even though child had limited leave to remain in the country. We've actually had a successful case today as well. In cases where child doesn't have any leave to remain at all, this is where we will have more difficulty. Again, there is no such category where application can be made within the immigration rules. Application can be made outside of the immigration rules, but I think in that case perspectives will be very low because child doesn't have leave to remain in the UK. Do you want to add anything?
No, I was just going to say, in terms of, you mentioned that in some cases parents are difficult and then the other parent needs to resort to getting a contact order. So actually most people are waiting to obtain a contact order before they make an application, but that's not necessary. There is an authority on the fact that as long as you made an application to the court to get contact, you can actually make an application, and typically they give you a 1-year visa and then you proceed from there on until you obtain full contact or custody of the child.
Can I just ask a question adding to that? For contact orders, do you have to go to the court to get such contact orders, or can you have an arrangement outside of court as well?
No, you could. If you have an arrangement, the basic principle is if the mother usually or the spouse consents, well, not a spouse in this case, but the other parent consents, then you don't need to go to the court.
Okay.
Yeah.
Next question is for Shara. This is an entry clearance question. Now, if a mother and father have come together to the United Kingdom and they've settled down over here, but they've left their child in a non-EU country,
Correct.
Can they call that child over, and if so, on what basis?
Yes, it is an unusual circumstance, but something that immigration practitioners usually encounter. The usual trend is economic migrants or otherwise, like even student migrants who come to the country, they've left their children behind. And of course, they start a new life here, and eventually, as they move on, they started working here. And in due course, they qualify and become British nationals. The children have been, or a child has been left behind, what to do in that scenario. So an application can be made for that particular child to get entry clearance and to basically come here and join his parents. But the test is a difficult one. The Home Office typically argues that they lose sole responsibility. So the legal terminology for this is sole responsibility, which basically means that you must be the person who is solely responsible for the child, and there's no one else abroad in the non-EU country who's looking after the child. And the way you prove that is that on a day-to-day basis, you're looking after the child in the sense that you're taking all the material, big decisions in his life, which could be basically as to what subjects he would study in school, if he even decides not to go to school, whose permission does he need to take? Is it the grandparents or the guardian back home? Or is it actually the parent who's here in the UK? So the more these parents are able to show that they're playing a role in these children's life who have been left behind, the stronger is the argument that they have sole responsibility for the child. So it's not a simple case. People do make the mistake of simply saying, it's our child, here's the birth certificate, we need him here in the UK. It's no longer that simple. Once you've left a child behind, you should see professionals who will guide you through the whole process.
Okay, thank you.
Just to add, I mean, in addition to what Shiri has said, there may be cases where a parent or parents have taken the sole responsibility of a child. So let's say via adoption process, or in a way that there was someone who was taking care of the child before, but now circumstances have changed and now parents have to take full responsibility for that child. So from the beginning they didn't have sole responsibility. Yes. Now they do. In these cases, would the same circumstances apply in terms of evidence?
Yes, of course. We would then again need to provide evidence that the sole responsibility has now transferred to the biological parents or the sponsors of this application. So it's not the end of the world that somebody else had sole responsibility before. So a very common example is that grandparents usually are left with the care of children, but then grandparents, as they age or would pass away in some cases, would then transmit the sole responsibility back to the parents here in the UK.
Okay, thank you. Now, last time, I understand due to IT technical difficulties, there was one question that was left unanswered. So I'm just going to ask that because we've received a lot of queries in relation to that question.
Sure.
Now, besides the entrepreneur tier 1 category that requires a heavy investment, is there any other category a business person can come to the United Kingdom?
Yes, well, you said business person. So for that, last time you were talking about the sole representative of an overseas organization. And as you mentioned, for the tier 1 entrepreneur category, you need to show an investment of £200,000. If applicants don't have that, but they still want to start up a business here in the UK, there's another category called a sole representative of an overseas organization. And what that requires is that you demonstrate that you have a business abroad. That business is not transposing all of the full headquarters here to the UK, but they're opening a branch office here in the UK. In order to do that, the requirement is that there isn't a requirement, a financial requirement to show £200,000. The requirement really only is to show that that person who's making this application is a senior employee of that organization abroad. That organization does not have any presence here in the UK, but they wish to open a branch office or establish some presence here in the UK. So one person, one senior employee typically of that organization, could then come to the UK along with their family members to basically set up that branch office and start the business of that overseas organization.
Okay, thank you. Now, given the shortage of time, we're not able to answer all the live inquiries that we have received via email as well. But if you have any inquiry that's left unanswered, you can always call our offices and either speak to Mr. Shearer or speak to Mr. Awais, and they shall deal with your inquiries. But I guess we shall call it a wrap today.
I think there are a few questions coming in online as well. One question we get all the time is there any amnesty scheme coming in like we had previously in 2010 and 11? I know our previous Foreign Secretary made a statement regarding amnesty for anyone who's lived here for 10 years. But do you want to comment on that?
Well, I don't think we would agree that so far we're expecting any amnesty to come through. But we do believe that once Brexit falls through, there would be definitely more routes announced for migrants abroad. I think I read somewhere that at least 5,000 nurses straight away would need to be employed from non-EU countries because there would be a shortage in that particular category. So as things progress, there would be more routes announced. But as far as an amnesties, concern, it does look difficult given the present government is so anti-immigration, if I may call it that. But it could happen, and of course, if it does happen, then we would all be well aware of that in due course.
Well, best thing to do is to go to our Facebook page and like our Facebook page. By doing so, you will get regular updates for any changes that are coming in, or you can sign up at our website for our blogs, and you will be updated regularly. In addition to what you've mentioned, I was reading a news, and I think put it on our Facebook as well, where government has announced that in the summer next year or spring, they will be allowing temporary workers to come as farmers in the UK. So they would come in to work on farms in the UK as temporary workers. I think it's a very good initiative government has taken. I think this is also to add to the work shortage they may be facing because of the Brexit issue.
Definitely, yes.
There aren't any specific regulations or rules announced as yet, but I think just as I said, go and like our Facebook page, and if there's any update, we will be updating you very soon. Just to add to the category we've just discussed, this whole wrap off in overseas business, a lot of times questions we get in this category is if the dependents can come in. Sharia has specifically mentioned that dependents can come in, even though there is no specific application form you can use for these dependents because it does not fall within point-based system.
Correct.
So you can't use P-based dependent form, but you can use an overseas application form for dependents to make an application. All you need to show is that they can be maintained and accommodated in the UK, and they can come in and make an application.
Absolutely correct. I mean, since we're talking about dependents, I'd also like to mention that in a recent case, the general presumption is if the dependent is over 18, then that person cannot enter on the dependent category. But we've been successful in arguing that on the basis of human rights, an over 18 dependent should also be granted leave along with their parents. Of course, there were compassion and exceptional factors to that particular matter. But again, don't basically just follow the rules, and if you think there isn't a form for this, that I cannot be eligible, speak to professionals. There's always usually a way, and hopefully that's something that's good that's come out of this particular case.
I guess.
I think it's a question on delay. We get these questions a lot as well. Okay, so pending applications, a lot of times, they're pending for 3 years, 4 years. How long is long enough to be considered as delay? Let's put it this way.
Unfortunately, I think in a recent case, judges basically ruled that even 6 years wasn't long enough. So although you would think even 6 months is a lifetime, the judges need to look at everything in perspective, and it's on a case-to-case basis. So if there's a criminal investigation pending, then the Home Office can actually put your application on hold for as long as that investigation is concluded. So that's happened to a lot of migrants who were especially affected by this ETS TOEIC matters or any other immigration fraud matter. So there isn't really a particular period. The only one fixed particular period is for EU migrants. So if they made an application that's been more than 6 months, that could be considered unlawful, and the Secretary of State has to consider applications for EU, EEA migrants within 6 months. But beyond that, it's a case-to-case basis. It's difficult to accelerate things when they're in court. But if they're with the Home Office, it's always possible to follow this up by calling them up or asking your lawyers to follow it up. If you're not getting a response, of course, then that's not in order. You could threaten them that you would go for a judicial review. But if they do respond and tell you what the cause for the delay is, then usually you do need to wait.
We've also received another live inquiry. Someone's asking if there's any update on TOEIC matters, recent update.
That's your favourite question, Gigi.
Well, yes, I was quite heavily involved with the case of Essen and Call last year, so I believe that's why we keep on getting these questions. I think the lead cases have already been decided, the last case of Khan and then the case of Essen and Call. So it's a case-to-case basis again. If you've had a judicial review unsuccessful in the past, it depends on what were the grounds. So the overall general update as of last year was that yes, it's not as simple as the Home Office said it is. It's supposed to be decided on a case-to-case basis. It's supposed to be decided on an evidential basis. All the evidence in that case needs to be considered, and the evidence of the client needs to be considered. So if you were deported straight away without being given an opportunity to go to court, then yes, there is good news for you as well. There's so many different variations of cases because we're talking about 45,000 cases. So I guess in simple words, the update is that yes, there was an update as of last year. There's recently been an update. It's good for these migrants, but they should speak to professionals as to what the particular set of facts are on their case, and then only can we say what is the latest for them.
Excellent. Just to add to what Shira has said, in the case of Khan recently, I think came in June this year.
Yes, it was just
Yeah, that case was basically everything that was said in your case of Core and Essen. It was confirmed by the court. In addition, the issue was because there were particular cases that where Section 10 was issued after the new under the new Immigration Act 2014, and in those cases, basically, generally in point-based system there is no right of appeal.
correct.
So the issue was how would these cases be dealt with. So I think one of the things the people who had these cases pending had to do was to make a human rights application. So they will be given an opportunity to make a human rights claim before the decision is given, and based on the human rights claim, Home Office will decide or courts will decide whether to grant in-country right of appeal or not in these matters.
That's correct.
I was also getting some curious regarding Home Office refusing nationality applications.
That's
they were
correct.
granted indefinite leave to remain previously. Applicants were granted ILR previously, even though they had TOEIC matters pending or concluded. But now that they have or never been brought up to their attention, now they have made a nationality application, and based on the previous TOEIC issues, their nationality applications have been refused. Now we know there is no right of appeal on this nationality application, and judicial review is not a fact-finding remedy. How would you suggest that they should approach these type of?
Well, yes, I'm glad you brought this up because I'm dealing with these cases as of recent times as well. And you're correct, applicants have been granted indefinite leave, but now the Secretary of State has started refusing nationality on the grounds of the good character test. I think, frankly speaking, it's absolutely ridiculous that the Secretary of State has decided to now refuse applications for nationality on the same grounds that they in the past denied immigration applications. Initially, of course, you need to exhaust the internal process of following through with the review of that nationality application if it's refused. But following on from there, the judicial review would appear to be a remedy. Courts have traditionally been hesitant to disturb decisions of nationality because there's a huge discretion with the Secretary of State. So if the Secretary of State decides that something amounts to bad character, then the courts would normally not intervene. But there have been a number of cases now where the courts have actually said no, the good character test cannot be completely down to the Secretary of State. There must be some yardsticks. And based on those same yardsticks, I believe that anybody who's been refused nationality on the grounds that they in the past have allegedly done this deception by taking the ETS TOEIC test, they should challenge these decisions. They should speak to professionals about this. And I think there are good prospects in a judicial review for this.
I mean, just an extension to this, we've also had cases where Secretary of State has lost cases in first year tribunal, cases related to deception issues, and later on when applications were made for ILA or nationality specifically, they would bring that issue back and say that either we didn't turn up or we didn't provide additional evidence in that appeal, and we are now relying upon that evidence. As long as there is no new evidence they can present, they cannot go behind the decision of the first year tribunal where they had their opportunity to come and argue the case and basically they lost.
Yes.
So if you are one of those where your application is refused because of a previous decision where you have won related to deception, then there is a very strong perspective that if you take this matter further by judicial review, there are good chances of prospects. So just speak to the experts and get the expert advice on this matter.
Okay, shall we call it a wrap given the shortage of time? If there's any other questions that you guys would have?
Well, happy to help. If anybody's got any more questions, please email us or leave us a note on our Facebook page and we'll get back to you.
Okay, but don't forget, you are getting our details at your screens. Make sure that you go and like our Facebook page, go and register yourself on our website for our newsletters, for our weekly updates, daily. Sometimes we put blogs few times a week, and Facebook we update it all the time, so you will be updated with all the required information we need for any amnesties coming in or any further categories that will be open in the future.
Or whether you need to pay a fee for a human rights application.
Exactly, yes.
Alright then, I guess we'll meet another time then. Until then, goodbye.
Goodbye.